Okay. Welcome back, everyone, um, to this session on dignity and constitutional personhood. Uh, and I'm sure it will give us an opportunity to unpack some of the points that Professor Daly raised in her keynote address in the inaugural session. If you were to start with and then there can be and there are many disagreements about how dignity is to be viewed. Is there a core minimum content, or is it in that sense contentless? And there is then further disagreement on whether its shapelessness is its value, and that it's good that it is a normative framework. It provides some sort of framework then that is capable and sensitive to local context and can be shaped in those local contexts, and therefore while there is a unifying structure, it can be infused with local experiences and contexts. And while there are those conversations on dignity, the point being, how does that translate into recognition of constitutional personhood, right? And even if we were committed to the position that dignity in its bare minimum might mean inherent worth or value to every human being, does that necessarily mean that it translates to equal constitutional personhood? And that's a complicated dynamic of which dignity does the law recognize, which does it recognize it equally? And one can think of that in various contexts, in the colonial context, in context of undocumented migrants, and the whole host of contexts, caste, religion, how constitutional personhood does not simply flow from dignity as in a straightforward manner as we might think it does. So to explore many of those issues, we have a terrific panel. And three of us here, alumni, and um, uh, Professor Daly, soon to be adopted, I think, from the. Great. Professor Pritam Baruah is the head of School of Law at BML Munjal. Professor Anshuman Shukla is faculty at Jindal Global Law School, and you've already been introduced to Professor Daly. So we'll have Pritam go first, and then Anshuman, and then Professor Daly. We'll take about 20 minutes each, and that leaves us with about 30 minutes for discussion at the end. Pritam, over to you. Yeah. Yeah.
Thank you, Professor Vasanthi, for having me, and thank you, Anu, for more. Works. Yes. Audible now? Yeah. Okay. So I think I'm the odd one out here because this is placed to be a prelude to a course on dignity, which is also looking at the application of dignity. And there is a dignity law clinic here, which looks at practice. I'm a legal philosopher, and I've done some work on law, on dignity, focused on the Indian court and on the philosophy of dignity. But as I was listening to the first panel and to Professor Daly's keynote address, I felt comfortable that there is space for some of the work that I have done to be spoken of here. And at the outset, I would say that it is very important to have a grip, at least some grip, on the content of dignity, even to speak about indignity. Because we heard in the last panel that, and Amartya Sen actually made that very popular, that you can't have grand theories of justice, but you can spot injustices. I'm skeptical of that view because how do you know something is an injustice unless you have some sense of what justice is and you put them in the same box? But the idea is a powerful one, that when we see humiliation around us or when we see treatment that appears to be morally wrong, we are able to spot it better than being able to spot what the meaning of a concept like dignity is. But just to start off, in the history of thought on human dignity, some of which has been spoken of today, there are four broad paradigms. And I think it's important to lay it out right at the beginning. The first is, I think, the broadest, and people were very skeptical of it, but now I think, it is coming back, which is the status-based idea of dignity. The status-based idea of dignity being that things have a special status, which is that they have dignitas, right? And that's why we say people who are on the dais, they are dignitaries. All of us who are not on the dais, not so, because they have a special status. And this kind of an idea is etymologically also rooted in the Latin idea of dignity, which is about a status that you might have. But as it is, and the philosopher Wittgenstein told us that as it is, the meaning of words changes, they change with usage. Um, the idea of dignity changed from this status based to what I think now is the paradigm now, which is the Kantian concept of dignity, which focuses on human agency, which is the idea that human beings have the power or the ability to find out what is morally true, what is the morally right thing to do. And that is an ability that we have, and now neo-Kantians say some other beings also have, not just us. And therefore, there is something special about human dignity. Until recently, in the law, it is this idea of human dignity, and Professor Daly also pointed that out, which has taken central space. But Saksham, in the last comment that he made, he said that we might be thinking about dignity of other things. And if you took the UDHR paradigm, and which is human dignity, then I think it would be difficult to think about those things. But if you went back to the old status-based idea, then you may think about the dignity of plants, you may think about the dignity of animals, because it is about treating them according to the relevant considerations that apply to them, given their status. And so plants, if depending on our definition of pain, plants may feel pain, they may have emotions, they can communicate with recent research from Germany and Japan. We see that there's a lot more that we come to know of them, but I'm not sure if the idea of dignity captures all of that. Some other ideas might capture. But the status-based idea, I think, still has some purchase in terms of expanding dignity. But in law, we have mostly had Kantian, I think the Kantian intrinsic worth account is dominant. The two other ones, one is the honor-based idea of dignity, which finds space in German law a lot. And that honorific account of dignity has often been used to curtail individual rights, mostly the freedom of speech in the law, that to honor dead people, you cannot be writing novels about them which are disparaging of them. And therefore, dignity has been used to limit freedom of speech and censor literary work in Germany. So the honorific account also is there, but it also has deep roots in the Holocaust, which is the idea that human beings have some kind of a honor which ought to be respected, that you cannot bring down at any given point of time. And therefore, it is close to the Kantian idea, but that the honorific idea in law has led to dignity also as a reason for curtailing of rights rather than as a source of rights. And the fourth account, which is not really spoken about, is a more Eastern account of dignity, Confucian accounts. There are some traditions in ancient Indian philosophy where all human beings do not have equal dignity. Dignity in this view, it is called the performance-based view of dignity. That depending on your actions, you will receive treatment which is deserving according to your actions. Just because you are human doesn't mean that you are entitled to anything. Only your actions speak for what you are entitled to. And this can, of course, sometimes be brought together with old Kantian accounts or Hegel's view, on punishment, which is the idea that because we treat you as a responsible human being and we respect your agency, we will treat you according to how you impact the world. And so your performance is the basis of treating you on the basis of dignity. But in dignity in the law, this account has not found much force. Some writing, mostly from Taiwan, and there are people in the City University of Hong Kong, Professor Moon, who has written a book on this Confucian account of dignity, which is a performance-based account. So there are some of these accounts on the table. But what I want to focus on, given that there are these many accounts, is that in the Indian context, we should be mindful of the gap between dignity enthusiasm and dignity inflation. These are two different things. I think we should be enthusiastic about dignity, but it has led to a kind of dignity inflation which has put us, at least in the Indian Supreme Court's jurisprudence, in a situation where we stand with contradictory accounts of dignity. And that's what I want to focus on in my presentation today. And it is this dignity inflation is mostly this idea. And, there are problems with it. People say that, oh, dignity can be used anywhere because we don't really know what it means. For example, there was a critical account by Christopher McCrudden on the Universal Declaration of Human Rights saying that dignity was accepted by everyone because people didn't know what dignity was. So it's easy to agree on something that you don't have strong views about, but you have some intuitions about. And that intuition might have a lot of purchase, it might have a lot of use. We should not really think that because you can't really specify, we should discard it. But the idea is that that kind of, let's say, vagueness about dignity has led to inflation, which is to say that dignity in the Indian context has been said to be a value, a right, a value justifying all our fundamental rights, a value justifying not just our fundamental rights, but also our directive principles. And most recently, dignity not only as a source of rights, but also as a source for limiting fundamental rights. So this is the kind of jurisprudence on dignity that we have today. But what dignity inflation does is that it makes us lose grip on the concept, and that is what I want to be cautious about when we use the dignity. Just like in democracy, when we think that democracy is the sole value, which captures political legitimacy for us, or democracy is the sole value which justifies government for us, I think we should be skeptical of such accounts, because there are many other things such as accountability, transparency, which democracy may capture and sometimes may not capture, but they are important parts of political legitimacy and governance. So I hold the view that even with dignity, we must be clear on where dignity applies and how, and the only way to do it is to work with examples and actual cases and bringing material empirically from the world, which will make us get a grip on it. Now, I want to spend some time on what has happened in the Indian courts, jurisprudence. And there is, I think, some hope here, for the reason that though some people like Jeremy Walden argue that dignity is not a moral value, dignity is actually a legal concept. I don't think that in the literature there is much support for it. Dignity is a recent legal concept, but it is a much older moral concept. And the legal concept and the moral concept, they interact in many different ways. And I think that it's the moral part which gives a lot of meaning to the legal part when we come to applying it. But what I think the hope with the law is that the law asks you to make things more specific, more fine-grained, and give reasons, which is non-arbitrariness, in your decision-making. And that puts pressure on institutions, on decision makers to flesh things out. And that, I think, has really been a game changer in India. So if you look at the history of how human dignity has developed in India, the Constituent Assembly debates no mention of dignity for fundamental rights or directive principles or for caste or for humiliation or gender. No. It was only the status-based accounts, that the dignity of officers, that who should get what kind of entitlement, what kind of houses should be according to the dignity of that office. That's the kind of discussion we have in the Constituent Assembly debates. If you look at the Constitution, the dignity appears in three places, right? Dignity, it's not even one of the capital letter values. It's dignity assuring fraternity assuring the dignity of the individual, and then by amendment, the unity and integrity of the nation. So it ties everything to fraternity, and I think it's a good thing, because fraternity makes things more horizontal, and we can really think of dignity in many more useful ways if we tie it up with fraternity. And Professor Upendra Bakshi in his work actually points that out, that at the same time that the UDHR was being drafted, the Constitution of India was being drafted, and we brought something to dignity language, which is that fraternity, which is obligation generating, and dignity, which is rights generating, because dignity is spoken of the individual, while fraternity is about the collective. And therefore, I think we should be comfortable with the idea that we can have obligations towards plants or animals or other human beings, even if we cannot clearly in a Hoffieldian sense bring out a right which really exists in them. It is possible with the new literature in jurisprudence on we may call the rights, but I think our obligations towards non-humans, we may have obligations without being able to have a right which they may be able to claim, which a right is a claim, and the claim one may not be able to make it, but still you may have an obligation towards them, right? So people in vegetative states, fetuses without brains. Those are the kind of dignity arguments which are really at the frontier. Now, I know it's around 7 minutes left, but in India, what has happened is that it is really the Supreme Court's jurisprudence starting from Francis Corell-Mullen, which brought dignity in. And I want to mark out three paradigms in this. One is that when we started with dignity, from Francis Corell-Mullen, we straight away moved to socioeconomic rights, which is with right to education, then right to food, right to a healthy environment, and several other unenumerated rights. Dignity has been a source of these rights. But within this source, there is a tension. In some places, the Supreme Court of India says that dignity requires the bare minimum required for human existence. So it's not animal existence, something more. But in other cases, it says that dignity requires everything that is required for human flourishing, which means that dignity can be a source for putting positive obligations on the state to a much greater level, like it happens in several of the Latin American countries. Brazil is one of the foremost there, where the constitution recognizes socioeconomic rights in a strong way, and dignity has been used to put obligations on the state to fund individual surgical procedures for people, saying that people have a right to health, and the right to dignity requires that the state funds this surgical procedure. We are not there yet, but it's there in our jurisprudence. The second kind of, I think, paradigm in dignity is that because we made dignity a part of Article 21, right to life with human dignity, and there is also personal liberty, sometimes we speak of dignity as absolute, that dignity cannot be limited, and sometimes we think that the parts of Article 21, we now know that it cannot be suspended, but the personal liberty part is limitable, and if it is limitable, then dignity also becomes limitable. So that kind of a contradiction does exist in our jurisprudence, something to be thought about. The third is that there was a watershed moment in the right to privacy 9-judge bench Puttaswamy case, the privacy case, which I think for the first time the Indian Supreme Court really started explaining what human dignity is. And it brought in a lot of literature from philosophy to say that human dignity is individual dignity, which is about the intrinsic worth of the individual, which is a very Kantian account. That, and that's why in later on in the Sabarimala judgment, Justice Chandrachud goes on to say that liberty, dignity, and equality are the founding faith of the Indian Constitution. There is something that links them together. But it was very clear, and I have some quotes, but not presenting it here, but where it has been clearly said that the elements of dignity, and maybe I'll read that out, that brings many things together for us, are respect, 5 minutes, respect for one's capacity as an agent, respect for the choices so made, and respect for one's need to have a context and conditions in which one can operate as a source of free and informed choice. All these three elements are about human agency, which is your right to self-determine and make choices for yourself. But right after this, in the 5-judge Aadhaar decision, which is the second Puttaswamy decision, Justice Sikri said that there's a fourth element to it, which is the idea of community dignity. And the idea of community dignity, simply put, and I'll just quote what Justice Sikri said. He said, dignity has a community value which emphasizes the role of the, and this is important, state and the community. It equates, it brings state and community together in establishing collective goals and restrictions on individual freedoms and rights on behalf of a certain idea of the good life. Now, this community dignity idea was picked up by Justice Nageshwar Rao in a later, decision called Association of Medical Super Speciality Aspirants and Residents and Others versus Union of India, to use dignity as a source for trumping individual rights. Now, where does this idea of community dignity come from? So my argument, and perhaps in Q&A it would come out, is that it has no philosophical legs to stand on. If you looked at all the traditions of thinking about dignity, and in the Indian Constitution, it is very clear. It is about dignity of the individual. In directive principles and in fundamental duties, it's about dignity of women and dignity of children, right? And doesn't talk about the dignity of the community. Now, the idea of community dignity, if we wanted to really explore it, can be of great value if we were thinking of community dignity, especially specifically in the case of discrimination and humiliation, such as caste or gender. In these cases, you cannot think of any humiliation or discrimination without referring to a group. So you may think of some areas of group dignity where humiliation cannot be expressed without thinking of a group, and there it may apply. But nowhere does this conception say that you can use dignity as a basis for limiting individual rights. Right? What Justice Sikri might be alluding to, and the basis for this actually is also an article by Justice Barroso, who is the Chief Justice of Brazil and the President of the Brazilian Supreme Court, who has an article on this called Here, There, and Everywhere, and Dignity's Place in the Law, I think. And there he brings out this idea of community dignity, but again, there's no reference to any philosophical tradition. There is some reference to communitarianism, but it's not exactly clear of how communitarianism translates into community dignity. So right now, and I have 2 minutes, right now we are in India in a place where we have had around 30 odd years of human dignity being a source of individual rights, mostly socioeconomic rights, and then Putuswami, which gives us a lot of material on what dignity is, and then the Aadhaar decision, which tells us that dignity can be a source for limiting your fundamental rights. Now, there is something which I want to pick up, and Professor Delhi said in the in her keynote address, that what is it about dignity that judges really want to go to, why they want to go to it for. And I think that sometimes it's not always useful. Sometimes it's an easy resort to not fleshing out other values. So if you had asked me that, okay, let's think about the right to education, what requires right to education as a fundamental right, I might have picked up social justice as one of the values in the Indian Constitution mentioned in the preamble. So, and flesh that out and said that, okay, this requires. There are many of these underexplored values in the Constitution, but if you easily resort to dignity, by excluding the other values, then I think it is problematic. And the tradition in Indian constitutional jurisprudence has been that we have left the other values and you have gone more towards dignity and picked dignity up and said dignity justifies this. And I think that is something we should be cautious about. But what is the promise and the hope of dignity? And I think that dignity is only one of the instances of the problems that are associated with when moral values are applied by courts. Unlike other legal concepts, there is no definition of these values. There's no definition clause. These values also don't have much legal material. It is much late that courts have given us some jurisprudence of dignity, but most of it is just the mention of the word, no explanation. So in that, I think that things like clinics, things like looking at instances of what we think are the violations of dignity, and courts should be, 3 seconds, I will stop here. And courts should take that mantle up, that they should be willing to, sorry, it's telling me to stop. So Anup's telling me to stop. But the idea is that if courts gave up what I call the Dworkinian view, and which Justice Chandrachud adopted, which is to try and relate all these moral values to each other and then bring out its meaning, and instead had the courage to look at real examples, which is the way of the common law, to look at different kinds of analogical examples and flesh things out, I think dignity has much more hope for us in the place for individual agency. And in the cases of humiliation and group discrimination, dignity has a lot to bring to the table. But I would definitely say that explore other values when it comes to plants or animals or to other beings. Dignity in the UDHR sense may not help us, even the environment. There are other values to be explored. And therefore, I think that with that hope, we should be enthusiastic about dignity without inflating it too much. So, thank you, Anna.
Thank you, Pritam, for that provocation of what has happened to dignity in Indian constitutional law. And also the challenge for us to think about that the conversation around what is the value and content of dignity might be better thought of as something reinforcing other values than the search for exclusive content